first case this morning is State versus Cruz. Appellant, you're the only party here, so you'll have 15 minutes to argue. Obviously, no time for a vote or anything like that. When you come up to make your argument, we are recording the argument, so please, when you come up, introduce yourself for the record. Make sure you stay behind the podium because we're visually recording you, and if you move around, we'll lose you. And speak loud enough so we can hear you when you are presenting that on the video as well. If you use the name of any, in this case, any victim, I don't think there's any minors or children, but any victim, please use initials rather than full names, if you would. With that, we read your brief already. Proceed with
Good morning, Attorney James Reed here on behalf of the appellant Nicky Cruz. In this case, I filed 4 assignment of errors. Originally, I was going to talk about the complicity jury instruction, but I think I'm going to start with the other 3 assignment of errors, which my client was indicted as a principal offender. And the 3 assignment of errors were the denial of the criminal rule 29 and then a manifest weight and sufficiency argument. And the facts of the case are the Barberton Police Department executed a search warrant at the residence. Mr. Cruz was outside the residence. There were 5 other people inside the residence. During the execution of the search warrant, they discovered some drugs and a weapon, and they charged only Mr. Cruz. And the case went to trial. I think 3 or 4 police officers testified. What I found interesting about the case was that during the search, as I indicated, Mr. Cruz was never seen inside the house. There were other multiple individuals there. None of them got charged. When they found the drugs and the weapon, they didn't perform any touch DNA analysis or fingerprint analysis on any of the evidence. There was no testimony offered by the officers that there was any evidence of drug sales originating from the property. During the search, they didn't find any evidence or records of any drug sales discovered. They had no cell phone records, no text messages, no social media posts, no confidential informant or recordings of any kind. The only thing they found besides the drugs and the weapon was approximately a little over $18,000 in the house, but there was never any testimony that established a nexus between that between the money and drug transactions. And in fact, during his post-arrest interview after being read Miranda, Mr. Cruz specifically denied that he engaged in any drug trafficking or possessed any of the drugs in question. And at the conclusion of the case, the state rested. Defense counsel made the appropriate criminal rule 29 motions, which were denied. But then at the close of the case, the state then asked for the complicity charge. And I think that was because the evidence that Mr. Cruz was the principal offender was just not there. It was very weak in that regard. And so when the state asked for the complicity charge, the defense counsel objected, and it was overruled and the instruction was given. And I guess the argument I'm going to make is that if you can't prove he was the principal, under the applicable law, you can't then argue that he supported, assisted, encouraged, cooperated with, advised, or incited the principal in the commission of the crime, or that he shared the criminal intent of the principal offender. I don't think the evidence was sufficient to show that Mr. Cruz was a principal offender, yet alone a aider and abetter. And that's, you know, the why I'm going in kind of reverse order of how I wrote it in the brief. I guess in closing, I would just say that the facts at the trial did not reasonably support the jury instruction of aiding and abetting, and it was not proper for the trial court to give that instruction. And I guess I'd make the argument that this is the exceptional case where the jury lost its way on the first, or the assignment errors 2, 3, and 4, but I'm also arguing the trial court abused its discretion in giving the complicity jury instruction. And that's about all I have, unless you have questions for me.
Seeing no questions?
All right, thank you.
On behalf of the court, thank you for your presentation this morning. The court will take the matter under advisement, issue a decision in due course. It will be mailed to you by the clerk of courts when it's released, also be in the highest